There is a document sitting inside the federal court record for the Western District of Arkansas that most people who followed this story have never actually read. It is not long, it is not complicated, but buried inside it is a string of language that reframes everything the public thought it understood about Josh Duggar and how the legal system ultimately saw him. Everything discussed in this video comes from public court records, verified news reporting, and official legal filings. That is the standard we hold here. The document is the government's sentencing memorandum, and what makes it worth examining closely is not just what it says about one man, it is what it reveals about how federal prosecutors build a case when they believe someone represents a genuine, ongoing danger, and what happens when a judge looks at that argument and finds it credible. So, let's actually walk through it, because the way this case was covered publicly and the way it was argued inside that courtroom are two very different things. Josh Duggar was the eldest child of Jim Bob and Michelle Duggar, the Arkansas family whose reality television show made them one of the most recognized faces of a particular kind of American domestic life. 19 Kids and Counting ran on TLC for years. The brand was built around family, faith, and order. Josh himself had worked in Washington, married young, had children of his own. By every surface measure, he was the continuation of everything the show represented. That image began fracturing in 2015 when reporting surfaced about incidents from his teenage years, allegations that he had molested 5 young girls, 4 of whom were his own sisters. The show was canceled. The family addressed it publicly. And then, over time, the cultural conversation moved on, until it couldn't anymore. In 2021, Josh Duggar was arrested on federal charges. A jury in the Western District of Arkansas found him guilty on 2 counts, receiving and possessing child sexual abuse material. And when the case moved into sentencing, what the government put on paper went significantly further than most headlines captured. The prosecution team on this case was not assembled casually. Assistant United States Attorneys Carly Marshall and Dustin Roberts handled the case alongside William G. Clayman, a trial attorney from the Department of Justice's Child Exploitation and Obscenity Section, a specialized federal unit whose entire focus is this specific category of crime. That combination tells you how the government classified this case from the beginning. This was not a matter that landed on a general prosecutor's desk. It was routed to specialists. And those specialists chose their language in the sentencing memorandum with precision. The phrase that anchors the entire document, the one that shows up in how legal observers have discussed this filing since, described the defendant's interest as deep-seated, pervasive, and violent. Sit with that construction for a moment. Deep-seated means the government was not describing a lapse or an accident. They were describing something they believed was rooted at a foundational level. Pervasive means not contained to one moment, not isolated by circumstance, but present across a pattern of behavior. And violent, that word carries specific legal weight. It is not a word prosecutors drop into a sentencing memo to make a point dramatically. It is a word they use because the evidence in their file supports it, and because they know that word will be read by the judge, referenced on appeal, and entered permanently into the court record. Here is what makes the government's argument architecturally strong. They did not treat the 2015 revelations as a separate story. They used them as foundational evidence of a pattern. In federal sentencing, prosecutors are permitted to argue relevant conduct, meaning behavior that establishes context even if it was not part of the direct charges. And the government used the earlier incidents not as background color, but as the spine of their dangerousness argument. Their position was essentially this: what we are sentencing today is not the beginning of a pattern. It is the continuation of one. That argument is what explains the enormous gap between the 2 sentencing recommendations. The government asked for 20 years, the statutory maximum. The defense asked for 5. That is not a minor disagreement about degree. That is 2 completely different portraits of who the defendant is and what he represents going forward. The defense was arguing for a man who could be managed, monitored, and rehabilitated. The prosecution was arguing for a documented pattern that, in their assessment, had never resolved. And then they made a point that is worth reading slowly. The government wrote, in effect, that a low-risk assessment is not the same as a no-risk assessment. What that sentence does legally is preempt the defense's most likely argument before it can gain traction. If the defense argues their client poses a minimal future risk, this line forces the court to ask, minimal compared to what? Because in this category of offense, where the potential victims are children, the acceptable risk threshold is not the same as it would be for almost any other crime. The government was telling the judge that even the most optimistic risk calculation still contains a number greater than 0, and that number matters here more than anywhere else. The judge sentenced Josh Duggar to 12 years and 7 months in federal prison. That outcome sits between the two recommendations. But what the judge said from the bench is what I think deserves more attention than the number itself. The judge expressed concern, directly on the record, that the defendant might reoffend in the future. This is the part of the case the public largely missed. The judge is not the prosecution. The judge is not an advocate. The judge is the neutral evaluator who is supposed to weigh both sides and arrive at a measured conclusion. When the neutral evaluator, in their own words, voices concern about future risk, it tells you something important about how credible the government's argument actually was. This was not an aggressive prosecution pushing a fringe theory. This was a prosecution making an argument the bench found persuasive enough to echo from the seat of judgment. The defense had submitted letters and character witnesses. Anna Duggar, who remained publicly committed to her husband throughout the proceedings, was part of that picture. The defense framing was one of support structures, community, and the possibility of change. The court weighed that framing. And the judge's public remarks suggest that what the prosecution put in writing outweighed it. What I think this case illustrates, and what gets lost when coverage focuses only on the celebrity dimension, is how federal prosecutors actually build a dangerousness argument. They do not rely on a single charge. They establish a trajectory. They invoke pattern evidence. They use precise language in documents that will outlast the news cycle. And when that argument is made well, it does not just determine a sentence. It puts a marker into the legal record that other prosecutors, other defense attorneys, and other judges will reference. The phrase about risk is already being cited in discussions about how courts should weigh recidivism in these cases. That is what it means when federal language lands. What the headlines gave you was a number and a name. What the court record gives you is the reasoning behind both. And the reasoning, in this case, was built deliberately, argued precisely, and ultimately found credible by the one person in that room who was supposed to remain neutral. That is the part of the Josh Duggar case that deserves to be understood clearly, not just what happened, but how the government argued it and why the judge found it convincing enough to say so out loud.